Good afternoon. My name is Tim Leshin. I'm the Chief External Relations and Advocacy Officer here at the Association of Schools and Programs of Public Health. We want to welcome you to today's ASPPH Presents webinar. This is about the Supreme Court decision on race and admissions recently. Before we get started, I did want to recognize the tragic events of 9/11 in 2001. Will you all please join me in a brief moment of silence? Thank you. Now I want to let you know that you can ask questions during the webinar in writing. You will see that's just my slide yet. You'll see a little box at the bottom where you can add the Q&A. And so I hope you'll do that. We have a number of people who are joining us today, and so we'll look forward to seeing those questions. And we'll answer those in the Q&A section. So when the Supreme Court decided to eliminate race in admissions, they prompted the question of our community in higher education and in academic public health about what will be the consequences for higher education. And so we are very privileged to have an excellent panel today of experts who will guide us through this and give us some sense of the implications and the intricacies of it. So today we have four wonderful panelists: Monique Dixon from the Department of Education, Peter McDonough from the American Council on Education, or ACE, our Dean DuBois Bowman from the University of Michigan School of Public Health, and our own Johnston King, who is the Director of Recruitment and Admissions here at ASPPH and really heads up the work with SOPHAS, which so many of our members use for the application process. So it'll be great to hear from Johnston as well. Okay, I want to get this started by kicking off and asking Monique to speak first. We're really privileged to have a voice from the Department of Education and her great expertise here. So I will turn it over to you, Monique.
Thank you, Tim. Good afternoon, everyone. I want to thank Tim and others at the Association of Schools and Programs of Public Health for inviting the U.S. Department of Education's Office for Civil Rights to participate in today's webinar. The Office for Civil Rights is the Education Department's law enforcement arm. We enforce several non-discrimination civil rights laws that prohibit discrimination based on race, color, national origin, sex, disability, and age. I would like to take a few minutes to discuss the U.S. Supreme Court's decision in Students for Fair Admissions versus Harvard and Students for Fair Admissions versus the University of North Carolina cases. I will collectively refer to them as the SFFA cases. And then I want to spend a few minutes to provide an overview of the resources the U.S. Departments of Education and Justice released last month to address some questions we received from college and university leaders. So let's get started on the holding of the case. In the SFFA cases, the Supreme Court held that Harvard College and UNC's admissions programs unlawfully considered an individual's race in determining whether to admit them to their schools. So specifically, the court held that schools' admission programs were unlawful under the U.S. Constitution and federal civil rights law, specifically Title VI of the Civil Rights Act of 1964, which prohibits recipients of federal financial assistance from discriminating based on race, color, or national origin. The court found that the schools violated those laws because the educational benefits of a diverse student body that Harvard and UNC presented to the court. Specifically, one of the schools said that one of the educational benefits was promoting the robust exchange of ideas. Those benefits could not be measured and reviewed by the court. The court also concluded that the school's admission programs did not have a logical end date by which they would meet their diversity goals and would no longer need to consider the race of individual students in admissions. And the court also concluded that the colleges and universities' consideration of race disadvantaged some racial groups, among other things. So while the court did not explicitly overrule 45 years of its cases that held that schools may lawfully consider an individual's race as one of many factors in college admissions to realize the educational benefits of a diverse student body, the SFFA decision substantially limits the ability of institutions of higher education to justify the consideration of an individual's race in and of itself as a factor in admissions decisions. So with that understanding of the case in mind, last month, OCR, Office for Civil Rights, and the Justice Department Civil Rights Division released two resources, a Dear Colleague letter and a questions and answers document to help colleges and universities understand and comply with the court's decision in SFFA. The Q&A explains that the court made clear that, and I quote this, nothing in its opinion should be construed as prohibiting universities from considering an application's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise, so long as the decision whether to admit the applicant is, quote, based on his or her experiences as an individual and not on the basis of race. So to the Departments of Education and Justice, this means that institutions of higher education remain free to consider any quality or characteristic of a person that bears on the institution's admission decisions, such as courage, motivation, or determination, even if the person's application ties that characteristic to their lived experience with race, so long as any benefit that that applicant receives, so if the applicant is selected for admission, is based on his or her experience as an individual and not on the basis of race. So in addition, our resources also provide information on the steps colleges and universities may legally take to achieve a diverse student body across a range of factors, including race and ethnicity. These steps include, among other things, carrying out targeted outreach, recruitment, and the use of pathway programs, collecting demographic data, evaluating admissions policies, and developing student yield and retention programs. The resource explains that the Supreme Court's decision does not require institutions to ignore race when conducting outreach and recruitment activities. Colleges and universities can still collect and analyze data on the racial demographics of applicants so long as the college does not make decisions based on the individual applicant's self-identified race or ethnicity. Colleges and universities can continue, we state in our document, colleges and universities can reevaluate their admissions policies to determine whether, for example, preferences for legacy students or children of donors run counter to efforts to promote equal opportunities for all students in admissions. And there are several other points that we raise in the documents. The Supreme Court did not, and our resource documents do not directly address areas beyond the consideration of race in college and university admissions. We realize that college and university leaders have additional questions, but we were really eager to respond to the questions about admissions as soon as we could. So I'll close by saying that, as you know, it's the job of, as Office for Civil Rights and the Department of Justice's Civil Rights Division to enforce the law as Congress writes it and as courts interpret it. The Office for Civil Rights stands ready to apply the law to the facts that come to us. And as always, we stand ready to provide technical assistance and resources, including information about schools' obligation to ensure equal access to educational opportunities for all students, including students of color. So with that, I thank you for your time, and I'm happy to answer any questions at the end.
Thank you so much, Monique. That was a very helpful description of the case and the work that you all do around it. Appreciate it very much. We're now going to turn it over to Peter, who will have a few slides and start his presentation.
Good afternoon, folks. Thanks, Monique. I said, folks, as we were in the moments before we came live, that the American Council on Education has been really in the front row watching what the Department of Education has done and the Department of Justice leading up to and in the weeks and months after the decision to be as supportive as possible to the higher education community. And you know, we're all very appreciative, and we also appreciate that it is on a long list of things that are expected from these offices, and to see the attentiveness that continues focused on this and very important issue that is going to be an evergreen one, right? It's tremendous to see, so thank you. And because this will be an evergreen issue, I think probably most of the folks who have come to today's webinar have been coming hoping for answers. You know, I've got this thing going on. We have a committee that we formed. We have a committee that we're going to form. We're about to charge a committee. We're trying to figure out who should be on the committee. What can I learn today that can help us? Well, we're not going to give you a lot of answers, but what we're trying to do is give you context and understanding of the environment that you're working within and how to approach some issues. And one of the things we've found at the American Council on Education in this area is that in order to understand where we are and where we might go, both collectively and individually as institutions and programs, it is really helpful to have an understanding of how we got here. And so I'm going to spend just a few minutes with a how we got here discussion, and then we'll continue on. So Monique mentioned the Equal Protection Clause. So that's the Equal Protection Clause of the 14th Amendment, and that is what the Supreme Court was primarily focused on in the SFFA case. The other implicated statute, federal statute that Monique mentioned, is Title VI of the Civil Rights Act of 1964. And as you can see here, and as most of you know, that is a section of the Civil Rights Act that is focused specifically on race and national origin. We all are wondering, well, you know, what are the implications, if any, about gender and sex considerations of gender, sex, etc. Well, you know, we talk a lot, probably almost exclusively about Title IX. Title IX is the Title IX of the Education Amendments of 1972. And you'll see on this screen at the bottom here, there's an exception in Title IX written into the statute that is about admissions to educational institutions. And when you read through the exception, what it essentially says is Title IX applies in the admissions context everywhere in higher education, except regarding undergraduate admissions at private institutions. And so, you know, I just thought it would be helpful to keep this in mind, that Title IX isn't the beginning and end of issues pertaining to gender discrimination as we think about it. We have the Equal Protection Clause of the Constitution that the Supreme Court focused on primarily, but not exclusively, in the SFFA decision. So, you know, these are the rules of the road, so to speak, that the lawyers and others that are trying to figure out how to navigate need to just generally be aware of. Now, we've heard about strict scrutiny. We've heard about compelling interest. We've heard about narrow tailoring. What does all that stuff mean, and where did that come from? Well, over the years, there was and continues to be, if you will, a way that these cases are analyzed primarily, again, but not exclusively, under the Equal Protection Clause of the 14th Amendment of the Constitution. And we make decisions all the time with laws, with how states act, with how others act, that frankly are discriminatory. You know, they're discriminatory, but not in an illegal way. They affect one person differently than another. When an admissions decision is made to admit one person and not admit another person, well, I've discriminated against somebody in a way. You're not going to be coming to my institution if you would want to. But not all discrimination is illegal. And so, you know, what are we talking about when we get to race, ethnicity, gender, etc.? We are talking about the types of decisions that impact folks where it can and it can be illegal. It might be illegal. Is it illegal? We don't know. This is the world we've been in. This is the world we remain in. And this is the world all of the folks that are joining this webinar today want answers to, and it's a challenge. So just know that there's different levels of scrutiny legally that the court is going to apply when there is a challenge to a question about how an action was taken. In the race and ethnicity context, there's this idea of strict scrutiny. The government, and in this case, it would be a public institution, and then under Title VI, it would be a private institution as well, must have a compelling interest. There needs to be narrow tailoring, etc. Open question, I think. Monique may differ in her view here, but open question about whether in 2023, gender discrimination would be subject to strict scrutiny if it was being analyzed by a federal court, or is it something less than strict scrutiny? Probably doesn't matter for all of us on this webinar. Just understand that there's an open question as to how intensely an action that has a differing impact on somebody on the basis of gender will be analyzed. So those are the rules of the road, and those are that's the context in which the Supreme Court arrived at the SFFA decision. Back in 1978, the concept of an educational value of diversity first emerged in an opinion that was joined by nobody else, by Justice Powell at the time. It was embraced in 2003. More formally and fully by the Supreme Court. It was assessed and reassessed in 2013 and 2016, and then we arrived at 2023, of course. But very interestingly, Ted Shaw, who many of you may know and have heard, has said in different contexts, some of which I've been sitting next to him when he said it in writing, he said it orally, he said this, that he left the court in the Bakke case devastated when it was decided. Why was Ted devastated? And that's because when Bakke was decided, the court actually ruled against affirmative action that had a primary objective of benefiting some applicants. Now, there's different ways that the phrase affirmative action is articulated and understood. Lots of folks have been saying leading up to and after the SFFA decision that these cases weren't actually about affirmative action per se. They were about diversity, higher education diversity. And you know, we're not going to discuss or debate that, but just appreciate that back in 1978, a majority of the justices said that an institution of higher education cannot use race to remedy disadvantages cast on minorities. But there was that opinion that I mentioned by Justice Powell, where he spoke about student body diversity. He said, I think that could be a compelling state interest. This case arose in the context of a graduate medical program. It was the University of California at Davis Medical School where the Bakke case arose. So right from the beginning, the analysis has been in the context of graduate education, and indeed, the first graduate education case came up in a medical school's context. In Grutter in 2003, the court formally embraced this concept of the educational value of diversity. And of course, there was a recognition that there's a secondary benefit for individuals, but that wasn't the primary reason that it was embraced. And so, we arrived here at the Supreme Court's decision this summer, as Monique told you what the court said. And basically, the court turned these screws so tightly that it was really hard for us to imagine a scenario where a school or a program within a school could articulate a compelling interest that would enable race or ethnicity to be taken into account in making a decision that advantages somebody and doesn't advantage somebody else. That's just the practical reality of where we've ended up. The court did not say never. The court did not say never, but this is the practical reality. Now, Monique also mentioned a part of the Supreme Court's decision that said, yeah, but there's something else. You might not be able to take race into account directly, but race can inform some experiences that you can take into account. And this was something that ACE and a lot of other higher education associations spoke to in our amicus brief. And I think understanding this concept can help in thinking about application in the individual setting. This came up at oral argument, and if you don't mind, I'm just going to play a short clip from this, and you can listen in.
Can I take you back to Justice Sotomayor's question? She described an applicant who came from an underprivileged school who maybe didn't have the best teaching, best opportunities to score well on the SAT. And I want to know whether, in your view of the world, if a student wrote an essay describing some of the experiences that Justice Sotomayor said, I struggled, socioeconomic diversity, racial prejudice, things that shape who I am. In your view of the world, could a university take that into account without offending the equal protection?
Yes, I think this court's precedents even note that the act of overcoming discrimination is a separate and apart distinction from race, in part because any member of a race may be in a position where, or a member of any race might be put in a position where they feel somewhat isolated or somewhat different.
Okay, so I understood you telling Justice Sotomayor that you thought that would not be permissible, but that's not your.
No, I think I meant to say what's different. What we object to is a consideration of race and race by
race
itself.
In a box checking way, as opposed to race in an experiential statement.
Which the record in this case is that they can give the preference based on the check of the box alone.
Thank you.
So that was the plaintiff's lawyer at oral argument in the SFFA case, and that led to the part of the decision that Monique mentioned. So I'm focusing on that because obviously we have issues about admission. We have issues about enrollment. We have other program design, financial programs, recruitment and outreach, student support programs. The decision will have a broader reach over time. There's no doubt about it. As the department has focused on appropriately in its Q&As, we have the decision and we have admissions and we have to figure that stuff out right now. But it would be naive to think it has no impact over time, whether because it will be cited in other cases, whether because it will be a basis for complaints, whether it will be a basis for negotiated resolutions. It will have an impact. But that distinction that was sort of hyper-focused on during that little clip is probably going to be the best way that I know of right now for folks in the moment to say, so what am I doing here? Am I just thinking about race or ethnicity and checking a box? Or am I recognizing that race or ethnicity is part of the context of what it is that I'm paying attention to here, or what it is that I need to be thinking about doing in terms of a supporting program or activity? So I'll stop there and invite questions at the appropriate time.
Thank you, Peter. We'll now hear from one of our deans who's confronted these issues for many years in Michigan, and turn over to DuBois.
Yeah, thank you so much, and like to just express that it's a pleasure to be here as a part of this conversation. Appreciated already hearing from Monique and Peter, and look forward to Kingston's or John the Q&A. So at the University of Michigan, we've sort of had a head start dealing with this issue. And for public health, what I would say is we've really tried to maintain a focus that will contribute to the work that we need to do in terms of the workforce. And that is the ability to recruit and train a diverse student body to shape the public health workforce, I think is now as important as it has ever been. You know, thinking about the complexity of the nature of the problems that we work on, some of the glaring health inequities that exist nationally, even globally, and, you know, the critical importance of partnering with communities and building trust. These things all, in my mind, make it necessary for us to really maintain that focus on building a diverse public health workforce. And so I appreciated the University of Michigan. There's another layer that, so the Grutter decision in 2003 was a bit of a precursor. In 2006, there was a constitutional amendment called Proposal 2 that basically eliminated the ability to use race, sex, color, ethnicity, or national origin in admissions decisions. And, you know, over time, this has had a significant effect at the University of Michigan in terms of our diversity efforts. We've seen a marked decline and a sustained drop among underrepresented groups on campus. Black students at the undergraduate level, for example, back in 2006, represented about 7% of our undergraduate student body. This has declined markedly, and now it's about 4%. Native American undergraduate students, seven. That has since plummeted to just above, you know, a tenth of a percentage point in 2022. And so there has been real impact. And, you know, that's something that we have to confront with the recent Supreme Court decision as we look to the future. But I would say, despite these declines, that the University of Michigan has worked extremely hard just to continue to advance and uplift diversity, equity, and inclusion. And I'll talk about some of the things that we've done thus far. Perfect. So what I would say that the Supreme Court decision, and this is an extension really of how I think of the impact of Proposal 2 at the University of Michigan, impacted the processes that we use at the University of Michigan, but importantly, it did not affect the institution's commitment. And seek and identify ways to pursue the institution's commitment and values around diversity through a number of strategies. And I'll give a few examples, but broadly speaking, I would say the examples really focus on deepening the applicant pool and building relationships, whether it's with communities, schools, other institutions, performing holistic review for admissions, improving matriculation, and then enriching the student experience. And so the admissions, you know, sort of the X's and O's of the admissions process, I think it's important to look at, but just as one of other factors that are important as we find our way forward. So my comments are going to touch on undergraduate and graduate strategies, as we have both programs present here at the University of Michigan. And, you know, but yet I'd like to acknowledge that, you know, some of the strategies will certainly be more effective for one. There are a few university-wide strategies that have been implemented at the university. And so these just serve as examples, but one is the creation of the Center for Educational Outreach, and this center works to strengthen partnerships between the university and K through 12 school systems and communities. And really it focuses in particular on historically underrepresented communities in the state of Michigan. The Michigan College Advising Corps is another example, and this is a diverse group of recent University of Michigan graduates who work full-time as college advisors in underserved high schools throughout Michigan. And then a third example is a program called Wolverine Pathways, and this program provides college prep and enrichment guidance for 7th through 12th graders from specific communities in Michigan. And one nice feature of this is all of the scholars who successfully complete the program and
DuBois?
reward for participating in that program.
You're going
another area that there's been, yes.
You're going in and out a bit, so I don't know what you can do with that, but just keep moving along. I appreciate it.
Can you hear me okay?
Yeah, now we can. Mm-hmm.
Okay, all right. And let me know if you have difficulty hearing me, and I'll see if I can make some adjustments. Okay. Another space that we've been focusing on is the external transfer space. And
oh boy, I was worried that might happen. So we seem to have lost DuBois for the moment anyway. So I think what we will do is we will move on to Johnston, and if DuBois comes back, we'll let him finish up his remarks. Johnston, will you please move forward? Thank you.
Yeah, thank you so much, Tim, and thank you all for joining us this afternoon. I've learned so much already. So just wanted to start out and thank my colleague Alicia Kuyate, our manager of enrollment operations here at ASPPH. She's been fantastic in her work of making sure that we're supporting our members. Also want to make sure I provide my email address. So if you have any follow-up questions that are specific to your institution and you'd like to discuss those, please reach out and contact me, and I'd be more than happy to connect with you. As a reminder, we strongly encourage members with questions and concerns to reach out to your university legal team in addition to working with ASPPH. So like many others have stated, ASPPH was working with our members during the months leading up to the release of the decision. These are a few examples of what we've done previously and what we would like to do moving forward. Alicia and I were able to go in and review the SOPHAS application questions that were submitted by all of our members. And we were able to make sure that the questions did not include language that may be conflicting with the release of the Supreme Court decision. We also reviewed our members' SOPHAS branding pages, making sure that members did not unintentionally include language which would be flagged as possibly conflicting with the Supreme Court decision. We did notify those institutions and we had very few that had questionable language, and so those institutions were notified and they were able to kind of make changes if they needed to, but that was our process of providing support for members. We've met with members individually, and we'll continue to meet with members individually to figure out how can they operationalize this change into their processes and procedures. We will be offering additional admissions training focused on holistic or mission-aligned application review. Mission-aligned application review is a way to reframe holistic admissions to ensure that we focus on how the applicant's academic and professional experiences and goals align with the university, school, or program missions and values. Liaison is ASPPH's technology partner, and they help us manage SOPHAS. They have hosted online training on how to use work groups to hide race and ethnicity from reviewers in SOPHAS. So in building off of what's previously been discussed, what they're helping us do is saying, hey, how can we make the checkbox, set the checkbox up so that our reviewers who are looking at applications cannot see the answers to the checkbox question. And that's one way that some people have shared that they want to manage their process to ensure that race ethnicity information is not included in the review process from that checkbox answer perspective. They've also provided a special section in WebAdmin in the Help Center on navigating SCOTUS decisions. They continue to make enhancements based on member feedback. And I really appreciate that Liaison understands that there's a strong sense of urgency to make changes quickly in response to the Supreme Court's decision. And so we look forward to continue to working with them on that. We look forward to offer some upcoming trainings that we feel like we'll be able to support our members in their review process. Our implicit bias and application review will bring awareness to how a reviewer's previous experiences impact how they review applications. We'll focus on how individuals can manage their own bias as well as manage bias within a group. Our building and admissions rubric training will talk about how to use a rubric to consistently evaluate applications based on the criteria identified by the admissions committee. We'll focus on building out a rubric that can help guide meaningful discussion within admissions committees. This spring, we're going to offer a training on creating a culture of mission-aligned application review. Connecting the application review process with the holistic student experience. And this will focus on how to take information found during the review process and strengthen and improve new student orientation and onboarding. Our leadership and management skills to facilitate a mission-aligned admissions team will support faculty and staff that would lead a review committee or manage the technical side of the application review. We understand and appreciate that there are many people that are involved in a review process, and right now it's more important than ever to make sure that everybody's on the same page and that everybody is consistent with the review process. In addition to the trainings that we plan to offer at ASPPH, we'd like for you all to consider some additional action items that you can take at your institution. Now is a good time to review and improve your current admissions policies and procedures. Make sure that the current policies and procedures do not unintentionally leave you vulnerable for any legal issues. And it's important to be able to show how and why your decisions are made, as documentation is going to be key for making sure that you're covering your bases with your review process. In addition to reviewing your application review process, it's a great time to review marketing and communications materials. Identify and remove language that possibly could conflict with the Supreme Court decision. We also would ask you all to consider meeting with current student groups to explain what the Supreme Court decision means on your campus and provide space for students to share their experiences and concerns. Students are extremely valuable members of our learning communities, and as we all learn and navigate this on what this change means for everybody, we want to make sure we're making space to make sure they are staying informed and making sure that they're up to date with what new initiatives our member institutions are initiating. That is kind of an overview of what we're doing here at ASPPH. I will, of course, follow up with people with additional instructions on how to register for the trainings as we finalize those dates and times. I'm going to turn things back over to Tim.
Thanks very much, Johnston. I think that's some very practical advice for our members who are tuning in. DuBois, I'm sorry about your technical difficulties, but did you want to wrap up your remarks very quickly?
Yeah. I think in the interest of time, we can just proceed and get into the Q&A. But just to recap, really, the responses at the University of Michigan as we confront the challenges presented by Prop 2 have really spanned that focus on deepening the applicant pool, and that's through lots of outreach and institutional partnerships. Some with certain communities here in the state of Michigan, some with historically Black colleges and universities, some in conjunction with tribal nations. And so these kinds of activities have been very beneficial. Secondly, the X's and O's of the review process, holistic review for admissions, and a few strategies there. And then improving matriculation, which takes dollars. And, we have been serious about our commitment to try to provide financial support for those in need. And then lastly, I would say is just enriching the student experience, for those students who are enrolled, who make it to the University of Michigan, really trying to make sure that we focus on the campus community. And there's been a campus-wide presidential-led initiative since 2016 on diversity, equity, and inclusion for faculty, staff, and students. But in context of today's conversation, is really important for the student portion as well.
Thanks so much. There's actually a question directly for you in the Q&A, so we'll just jump to that so we can cover that. Asking that you mentioned something about incentives for those who participate in their pathway program, but they couldn't hear what those incentives were.
Yeah, so for, we have a few programs, but perhaps where where I went out and there was a connection issue was just saying for people who completed the program and were admitted to the University of Michigan. So they still have to go through the admissions process, and the admissions process is still, sort of governed by state law and now federal law. But for those who make it through and are admitted, they actually receive full 4-year tuition scholarship to the University of Michigan.
That's excellent. Thanks so much. There's also another question. Yes, this webinar is being taped and will be available for others to view or for you to go back and review later. Now, I have some questions that I want to run by all of you. So this seems like a basic question, but I want to make sure people understand the answer to it. Will institutions have to change their admission process now, or do they have time to implement it over the year based on the ruling? Monique, I don't know if you want to try that one or.
Now, the law goes into effect immediately. There were no provisions in the decision that said that there would be a delay. So yes, the SFFA decision is in effect right now and will have an impact on 23-24 admissions.
Thank you so much. And will you all in the Department of Education be providing any further guidance, or have we seen the guidance that you're going to be providing?
Well, thank you for that question. Your viewers may recall that the White House in June released a fact sheet on the administration's actions to promote educational opportunity and diversity in colleges and universities. And in that fact sheet, the Biden administration announced that the department's Office of Post-Secondary Education will release a report highlighting strategies for building diverse and inclusive student bodies on campuses and on the campuses of colleges and universities. So we anticipate releasing that report in the coming weeks. That is something that will be available for your membership.
Wonderful. Thanks so much. All that guidance has been extremely helpful to us and our members, and I'm sure the whole higher ed community. So I appreciate it. Peter, perhaps this is for you. Can you give us a sense of how universities are approaching the response to the ruling and the inability to use race in admissions?
Yes, of course, so much is contextual, right? And so much is based upon where one sits, both in terms of the nature of the institution, the nature of the program. Are you undergraduate? Are you graduate? Are you in a state where there are additional restrictions in the nature of laws, et cetera? But if there's one overriding reaction that I think I've sensed, it's as follows. Before the decision, a lot of folks thought about these issues as ones that affected primarily undergraduate admissions and at a fairly limited number of schools. And so if there's one thing that's happened, I think it is the recognition that while the decision was about, shall we say, hyper-exclusive admissions at Harvard and UNC undergrad, the principles that are now well understood are ones that are going to travel, not just through admissions into other programs, but also potentially into issues pertaining to activities and programs. And I think at a high level, there's some comfort in the call to action that this has created. Not that folks were overly comfortable or all on autopilot, but people have a lot to do, and this is prioritized, taking a hard new look at why things are done, how they are done, with, as DuBois had said, continuing recognition that there's not a thing in the Supreme Court's decision that questioned the higher education intensity of focus and determination about a diverse learning environment and the importance of that. There's not a word in the decision that questions that. In fact, we can find a lot of words that support that, even by folks who might not be immediately thought of as being the most supportive justices on the court for what we're trying to do. So, this is a call to action rather than necessarily a roadblock. And I think I've heard a lot of that.
Peter, thanks so much. I think that's very helpful context for others who are confronting this. There's a question in the chat, in the Q&A, saying, how does the ruling affect the ability to set DEI goals, in admissions? And DuBois, maybe you can reflect on that given your experience.
Sure. I mentioned that we have a university-wide diversity, equity, and inclusion initiative that's been in place since 2016. Now, there was a 5-year runway, took a year, collected lots of data. Now we're on a second 5-year runway. And the way that it's developed, each school and college, the 19 units on campus, develop specific plans in addition to the universities. And we continue to proceed with that kind of activity. The proposal 2 in the state law, now the Supreme Court decision doesn't, in my view, have any bearing in terms of how we, the goals that we set, the things that we value, the things that we feel will help us train students that will be able to go in and do effective public health work. How we go about doing that from an admissions perspective is the part that's constrained. So we still continue to collect data. We track data. We discuss it openly. It's just that component of the admissions process that has been altered.
Yeah, that's helpful. And maybe Johnston, you could talk a little bit about what SOPHAS, has done in that regard in terms of, you talked a little bit about it in your remarks, but how are institutions who use SOPHAS for their application process handling this issue? And, what should people be doing in terms of race in the admissions process?
Yeah, I think one thing I'd like to reflect on is that there's been some good discussion about building relationships with students. And so I think that building those important relationships with the prospective students is going to now be more important than ever. And I think that's something that people can kind of focus on. And so those pathway programs and other opportunities to kind of connect with communities will be important. I think that from an operationalizing side on SOPHAS is what SOPHAS is going to provide people with is the opportunity to rethink about how they're viewing the information and rethinking about what information they want to not view. Specifically, the checkbox answers, but it really will give people a chance to focus on other components on the application, like the personal statements or letters of recommendations, or as students are able to talk about their experiences. So while the removing of the checkbox answers is a big part of this process, it's equally, if not even more important, to pay more attention to and take time to really thoroughly evaluate the application. So it's sometimes while this is about what is it removing, it's also about like what are we going to make space to add. And I think that SOPHAS does a good way of highlighting the different information components in the application to allow our reviewers to make the most informed decisions about who they would like to join their educational community.
Wonderful. Thanks. That's really a good point. I like that. So a question in the chat in the Q&A is, does the SCOTUS decision have any impact on advertising to students who are first generation learners?
So let me just make this more general point. The decision does not inhibit the inputs that go into strategic outreach that an institution or a program within an institution may embrace. You don't need to put blinders on, stick your head in the sand, and pretend the world isn't what the world is. So with that as an overall context, when we start talking about things like first gen, the decision's not speaking to that, right? The decision is not at all speaking to that. There are going to be decisions made, and I think there was some reference to programs that may exist in Michigan about the value of focusing on particular communities within a state, making decisions about how to go places where maybe we haven't gone before. Why haven't we gone there may become less relevant than, what do we see as the benefits for going there? We'd be naive to say that nobody's going to question the motivation for those. And that is probably a good reminder for make sure you have a logical, sensible reason for that. This isn't replacing check this box with check another box. This is sort of an opportunity to reevaluate what you're doing, why you're doing it, and let's see if we can even do it better.
Great, that's super helpful. Thank you. So Monique, institutions are getting letters from Fair Admissions and America First Legal saying that they're going to be watching institutions to make sure they're not violating the Supreme Court ruling very closely. So I'm wondering if you think, what's your sense of additional lawsuits that may be coming down the pike on any of this?
Well, thanks for the question. We have heard about the letter. And it's really hard to predict what lawsuits will come. But, we at OCR have certainly received complaints as a result, subsequent to the SFFA decision. So we will continue to do what we do. We will look at the facts in the law and apply the facts to the law on various complaints that we receive about college admissions and make a decision accordingly. So, all we can do is continue to be the enforcement office that we are and to share with our colleagues, all of you, our view of the law and the school's obligations under the law.
Yeah, I'm glad you mentioned that you all are in charge of the enforcement here, and you will be getting those kinds of complaints, I'm sure, and we'll all be watching very carefully to see how you adjudicate those complaints. And that's an important part of the administrative process here as well.
Tim,
Um,
can I comment briefly?
Please go right ahead.
Yeah. So, this is certainly an area of concern, and I would agree with things that we've heard from our experts on the panel of the likelihood that such complaints, if not lawsuits, come forward. It is my hope that this is where institutions can really sort of determine the institutional risk tolerance, because often the harm of a law is not just the law itself, but the chilling effect that comes with it, right?
Mm-hmm.
And we certainly with each institution in its own context have to think about in concert with the local legal team, et cetera, what things are permissible under the law, what things are not permissible. But just to generally state, my hope is that we do maintain our values that sort of have shaped higher ed, and allow it to be really a special place as we think about a driver for social mobility and things like that we do maintain our principles and values.
Yeah, thank you for saying that. And that's certainly, those are the principles and values of the Association of Schools and Programs of Public Health writ large. And we really want, we've been focusing on diversity, equity, inclusion for more than 20 years. And we really want to make sure that we don't lose the great progress that's been made in that regard. But we know now we have a slightly different playing field based on this ruling. And it's encouraging that you at Michigan have been able to traverse it as well as possible, although this frustration of the numbers of diverse students going down is always going to be an issue here. And we'll really want to come up with creative ways to try to solve for that without violating the law. So we are coming up on the end of our time. I will just ask an open-ended question for the panel. Based on this ruling, what do we think? Do you think that legacy admissions are going to go away as well?
Well, I'll start here. I think that individual institutions are probably on one level or not already looking at this issue, and they're asking themselves questions in the context of what I've been talking about here today, rather than a check the box thing. What do we do and why do we do it? And I think institutions will answer that question differently for themselves, and they'll do it through different processes. And then they might ask the questions, well, how do we do it? So you might find an institution that has considered at the undergraduate level legacy admissions during the early admission or early action stage. And they might say, well, we're still going to consider legacy admissions, but not at that stage. We'll consider it at the regular admission stage, and there might be very logical reasons for that. Or they'll be training differently, or maybe training more precisely, I should say, because just like when race and ethnicity were permissible to be considered, it was supposed to be in a truly holistic admissions process, a thumb on the scale, so to speak, so that it isn't hard to kind of imagine this, I guess, in reality, but the court had said over the years, it can never be determinative. It has to be, one of many factors. Well, maybe in some contexts, legacy has become, if you will, more than a thumb on the scale. So there might be an evolution in an institution to a different place without saying yes or no. So my short answer to that is I don't think it's going to be a simple question. I think it's going to be decided differently. I'll be surprised if the law compels legacy not to be considered unless there was remarkably some consensus in Congress that sort of forced that issue in the nature of, how we once went from a speed limit on highways to from X to Y. Are we going to have speed limit adjustments by way of Congress on this issue? Never say never, but I'm not seeing that.
Well, thank you. I realize we're really at the end of our time. I want to thank our panelists who just provided some great insights. I hope it was helpful to our audience, but we will be accepting questions. Beyond that, we will provide the tape of this webinar to anyone who wants to see it later. And thank you so much for all of your help here today. And here's wishing that we will still have a very diverse pool of applicants and admissions in all of our schools and programs. Thank you.